today? Okay. I'm sorry?
Shortly.
Yes. All right, let's take a 10-minute recess, and we'll go ahead and get the announcements on the record in just a moment. Mr. Goff.
Okay. I had something I wanted to bring up. I can do that after the recess.
We're all here.
Your Honor, I would note again, it was brought to my attention over the last break that we have a potpourri of political statements parading out in the foyer in front of this courtroom. And again, we don't understand how this First Amendment activity, which is prejudicial to our client's case, continues to happen inside the courthouse. And I'm not picking on anybody, but it continues to take place. We had a huge protest. When I have access to a color printer, I'll print out some exhibits. We had a huge protest at lunchtime that was so loud with bullhorns, literally 20 feet from the front door of this courthouse, that you could hear what was being said at the doors of this courtroom within the facility. And again, that all goes back to our concern about the fair trial. But the most pressing concern I have is, because I can't read the minds of other counsel in this case, is my assumption is that there's one more witness yet to come, but based on the last couple witnesses, Your Honor, it's not for me to make an objection to character evidence presented against a co-defendant. That's an issue for other counsel to deal with if they think there is an issue. But I heard testimony today, for lack of a better characterization, as vigilante social media posts or communications involving co-defendants. And then, you know, we have this after-the-fact conspiracy evidence coming out from the last witness. I believe that was Subi Lawrence, talking about her talking to the McMichael defendants, or one of the defendants, about the famous video in this case. I felt under 403 it was more prejudicial than probative in the case, but technically that evidence as presented didn't directly refer to my client, although you could put things together as to where this famous video is coming from. But we're right at the precipice of getting into and establishing or suggesting an after-the-fact conspiracy involving my client. And that's going to raise some serious severance concerns, because now my client is going to trial with two Dirty Harry style vigilantes, if I understand the import of these of the post. And we now have this after-the-fact conspiracy, which the state has cleverly found a way to get right up to the precipice without actually implicating my client in it. And again, that's going to put us in a severance posture. And if I'm right, the next witness that the McMichael defendants are calling, I suspect we're going to get into more of the same. And if, in fact, the state has intentions of going into any more after-the-fact conspiracy evidence or vigilante evidence in this case, then I think that the court should address what they intend to go into before they do it, and not make me stand up and object in the presence of the jury. Because I'm just not as fluid as some of the other people in this case with these 803s and 403s, and heaven forbid I would make a speaking objection in front of the jury that the state might find objectionable, or the court might find objectionable. So if the state intends to go down that path with the next witness, then I think we need to take that up outside the presence of the jury before their cross-examination.
If I knew who the next witness was, I might be able to address this.
All right. I am not aware of the relief the defendant is seeking. That was a broad brush, Mr. Goff.
It was.
So I guess we are noting it for the record?
We are noting the severance issue for the record, and to be more specific, if the defense, I don't know what they're doing, but if the defense is going to call Diego Perez, who I had thought the state was calling, but they decided not to call. I had thought the defense was calling. Maybe they're not calling, but if they're going to put him up and the state's going to backdoor in vigilante issues involving the co-defendants or after-the-fact conspiracies, before the state does that on cross-examination, I think we need to take that up outside the presence of the jury.
Well, the court will take that matter, I'm not even taking the matter under advisement. Duly noted. Let's go ahead and take a 10-minute recess.